Call this work session order. This is our work session that's scheduled to run for 2 hours. And this is on our 2015-96 S1 and the amendments that are being generated on it. Let's go around the room and identify ourselves for the record. Julia, we'll start with you.
Julia Tucker, Assembly Council. Amy Koski.
Bill Starr.
Elvie Gray Jackson.
Dick Trainey.
Pete Peterson. Jim Stino.
Bill Evans.
Okay. I've got a note for you guys. Let me read it to you. The purpose of this work session is to get everybody up to speed on the proposed amendments to the Equal Rights Ordinance and to get through all 17 amendments. There are a few. So the Assembly is better positioned to take action on the Tuesday night meeting. I'd like the proponent of each amendment to take up to 1 minute for an overview. Then we'll open up to questions and comments. But because there potentially could be 11 Assembly members and 17 amendments, please keep your questions and comments focused so we can get through all of them. And if it's dragging on, I will ask you to sum it up, because you only got 2 hours. Welcome, Mr. Falsey.
Happy to be here.
Do you want to go over it before we start this? Would you go over your response to the questions that were given to you?
I'm happy to do that. I'll say that because it was a request for legal services, it is an attorney-client privilege exchange. Privilege is, of course, the Assembly's to waive. The request originally came in from Assemblyman Starr and from yourself. If you're happy to have this conversation in public, I'm happy to have it in public.
I'm waiving the attorney-client from my perspective.
I did via email last night, and so you know the correspondence I sent to you made it to all these family members as well. So full disclosure.
So as I structured the two incoming requests for legal services, included 3 questions presented. First was whether the Anchorage Municipal Charter would prevent the Assembly from prohibiting forms of discrimination on the basis of sexual orientation or gender identity by ordinance, or that that could only be accomplished by amending the Charter. We looked into the question and reviewed the language of the Charter, relevant history, relevant case law, and our answer to that question is unambiguously that the Assembly may prohibit discrimination on the basis of sexual orientation and gender identity without a prior Charter amendment that is consistent with the language of the Charter, which clearly calls out those items which are prohibited to the Assembly, and clearly calls out those items which must be submitted to voters, consistent with prior advice rendered by the Municipal Attorney's Office in the early 90s, and it seems to be consistent with the law enforcement dealings law.
Mr. Starr has a question for you. Okay.
There was actually.
When he's done that, I'm going to come back to you first, Mr. Starr.
That wasn't really the paraphrase question, but go ahead.
Sure. So hopefully we'll have gathered them all by 1, 2, and 3, and if that's not the case, I'm happy to provide
Okay.
additional insights here. The
Thank you,
second
Bill.
question is whether the language of the ordinance would be sufficient to provide sufficient guidance to the Anchorage Equal Rights Commission and Alaska courts to potentially balance the competing equal rights and First Amendment protections. The answer to that question is yes, it would. That the ordinance would instruct the Equal Rights Commission and Alaska courts to treat sexual orientation and gender identity discrimination in the same manner that they currently treat claims of discrimination on the basis of race, color, sex, religion, national origin, marital status, age, or physical or mental disability, and that existing legal framework can be expected to handle those claims without the need for any additional extraordinary guidance. Regarding the question posed by the ministerial exception, it is noteworthy that the code today contains no codified ministerial exception. It contains a religious preference that allows religious institutions to offer preferential treatment to their own adherents. But it doesn't codify anything like the United States Supreme Court's ministerial exception, which includes certain non-discrimination measures from being applied to the deployment decisions related to religious organizations and ministers. The codification that is proposed in the ordinance, we think, would provide a clearer basis in the municipal code and sufficient guidance in this admittedly still developing area of law for the Equal Rights Commission to deny claims or refuse to hear claims that would be barred by the U.S. Constitution. And then finally, there was a question that I interpreted as asking if Title V is made more protective than state law, may the Anchorage Equal Rights Commission continue to avail itself of court systems, and will individuals still retain the right to appeal their decisions to the Superior Court? Our answer to those questions is yes and yes, that the code would continue to authorize the Equal Rights Commission to seek court assistance. Individuals would continue to have the right to appeal, that the Alaska courts would likewise remain similarly authorized to support the Anchorage Equal Rights Commission to hear such appeals. It is as a matter of routine that now the municipality enlists the assistance of courts to review municipal code provisions which are wholly unlike state and federal law provisions. For instance, all of Title 21, all of Title 23 are building code or land use permitting code, so they're not within state and federal law. We rely on the court system's review and enforcement of that. If there are other questions that the Assembly would like to pose, I'd happily address them.
Thank you, Mr. Folsey. Mr. Starr.
Like, how about all of mine?
I think that
I'm not being flippant, but I specifically wanted some written summaries as well as the Article 17, which talks about, in the charter, specifically Article 17, it lists all the criteria that the Equal Rights Commission is supposed to use based on the charter authority. How can we, in being the overarching document that the charter is, how can we be selective and change the codified language solely in Chapter 5?
Through the chair, I'm happy to address that, and I believe the memorandum as related earlier this morning does get to that. So there are 3 provisions of the charter which address equal rights provisions. The first is in the Bill of Rights, which guarantees the right of people of Anchorage to certain opportunities in the creation of equal rights commission, and the right of opportunities include those in housing, public accommodations, employment, and education without regard to race, religion, sex, color, national origin, marital status, and physical disability. The second 2 obligate the Assembly to enact ordinances against invidious discrimination on those grounds, and the final requires the Assembly to establish the Commission and prescribe its duties.
Well, if I can spar with you just for a minute, the invidious discrimination, as you said that, lists specifically the categories of that, and it does not include sexual orientation or gender identity.
And our office's guidance and longstanding opinion has been that establishes a constitutional equal rights floor, not a ceiling, that guarantees a minimum equal rights protection for the municipality, but it doesn't prevent the Assembly from expanding protections beyond that floor.
I would beg to differ on that Assembly authority to policy change based on what the charter guidance is or voter mandate. So when you talked about Section 7, which talks about the empowerment thereof, but in Section 9 of the Bill of Rights, or excuse me, the powers and duties enlisted to the Equal Rights Commission, it talks about, and this is number 9 of my question, number 2, which talks about that the mandate under number 9 is paraphrased, I'll read the whole thing, review complaints of discriminatory acts and practices made to the Commission and prioritize allocation of its staff and Commission resources among complaints received in order to best fulfill the purposes of Article 17, Section 17 of the Home Rule Charter. By prioritizing investigation enforcement activities, the Commission shall seek to eliminate unlawful discrimination practices in the most efficient manner. So the Bill of Rights number 9 talks about it in specific reference back to the charter empowerment in Section 17 and particularly 1701, which lists those in the absence of sexual identity or sexual orientation, gender identity. So now we've got specific charter guidance on what the charter or the Equal Rights Commission is supposed to enforce, and yet you feel comfortable saying that they can go beyond the charter mandate?
Mr. Chair, I do feel comfortable saying that, and I think it is not a closed question. The charter also requires the Assembly to establish the Equal Rights Commission and prescribe its duties, but much more broadly, even beyond the context of the equal rights ordinances themselves, it vests in the Assembly the Home Rule Charter allows the Home Rule Borough or City to exercise all legislative powers not prohibited by law or charter. And it vests that legislative power in the Assembly, subject only to the limitation of where powers have been denied to the Assembly by the Charter, or they're required to go to the vote, to the people for a vote. In the equal rights context, there is no power that is denied to the Assembly, and there is no requirement that those questions be put to the vote.
Well, the equal rights empowerment is in the codified language in 5 and not what you're referring to in Charter 17, which is very specific to what they can enforce.
Sorry,
Mr. Folsey?
You referenced the Chapter 5 when you talked about the Equal Rights Commission and the empowerment provided by the Assembly. But my point is the Assembly doesn't have the authority based on the Charter under Section 17, number 9, and all the listings to empower them further than what's listed in the Charter.
And we may cross some purposes with our Charter references. Section 1702 of the Charter affirmatively authorizes the Assembly to prescribe the duties of the Commission.
Under the criteria listed, which
does
is
not expressly say that.
Yes, it does. Number 7, sir.
As a minimum, the Commission must address all the things in the Bill of Rights, Article 2, subsection 7.
So there's the nuance then, is you're saying, you're subquoting the minimum because that word's not in there.
That's right. But the charter does say all powers are vested in the assembly, they're not expressly defined. So as
Or
a
the
matter of
categories
course,
of
right,
race,
so as a
color.
matter of course, the assembly could not refuse to empower the commission to hear racial discrimination claims or to not hear physical disability claims, because the charter says those must be part of the commission's view. But there is nothing that prevents the assembly from assigning the commission additional duties. And in the 40 years of the municipality's existence, that appears to be the shared understanding. We've cited for you proceedings that occurred in 1975.
I haven't seen the citing, so I would like to see those. However, my research just says we've done it both ways. We've gone to the voters for 2012, we went to the voters for, we went to expand the physical and mental capacity. We went to the voters to change our charter language in that. So I don't know that it's a clear cut that we've never gone to the voters or that we've always done it by assembly ordinance. So moving into the next vested statute, you talk about the home rule charter as it relates to that, but the home rule charter concept and the ability for the Anchorage Equal Rights Commission is empowered in state charter. In the references in my letter, which I talk about the 44. That's sort of two reasons. Backstop, should we not be able to resolve the questions at a local level? And then secondarily, which is sort of the oversight watchdog of the Equal Rights Commission's power through home rule charter. Home rule charter is empowered by the state down to us. So when you talk about that, how is the Equal Rights Commission going to have the sounding board of the state, the background of the state courts, and all the others in that? And do we need to, secondarily, which is not in my letter, do we need to expand our methods and procedures inside the Equal Rights Commission to guarantee that, knowing that we don't guarantee fair process and due process, knowing that we won't get it at the state level?
So through the chair, to close the loop on the prior conversation, the disability example is actually a great example, because we did go to the voters to change the language of the charter to alter the phrase nomenclature from physical handicap to physical disability. That changed the words in charter and was only be accomplished by voters. But in the same year, 1993, the Assembly itself added protections to Title V for mental disability, which is not covered in the charter. So we think it provides an even further helpful example of how the Assembly does it.
Yeah, except for the reasons of going to the voters was to align and prescribe. As I did my research, it was align and prescribe based on changes in state and federal law. So in this case, we don't have the state or federal law telling us gender identity or sexual orientation is changing. So the reason we went to the polls back in that capacity. But if you more align with the reason we went to the polls in 2012, that was specifically to answer the question. So I don't know that we can use that as a legal precedent from that. But we go back to the state question about.
Gentlemen, I've got to interrupt you guys.
I'd like to hear how the state is
I
going to
know.
respond.
Let me just interrupt you for a minute.
Or put it in writing.
Mr. Hall, you're online? Ernie?
Yes, I am.
Okay. Please continue with what you need, Bill.
I just need to know the last answer to the question verbally, and then if you can put it all in writing, I would appreciate the answers.
Sure, and I think that whenever the Assembly's had the benefit of the time to go over this lengthy document, I think the answers are all contained in this document. This next
When did they
question
get sent?
this morning at 10:30.
Okay.
So, on the specific question that was just asked, I think there are two responses. The first is that the scope of the things that the Anchorage Equal Rights Commission deals with are not dependent on state or federal provisions. So it is not the case that the Anchorage Equal Rights Commission is only exercising powers that are derivative of a federal law or derivative of a state law.
I get that.
All right, so, and then the second.
But
refers to
mine was
specific
more of a
items-
process question,
Right.
sir.
The specific items that the specific citations that you had in your request were to AS 4462-560 and AS 62-570.
Through, is what I meant.
And there are only two provisions,
Yeah, right.
560 and 570. Those are just procedural mechanisms where one governs your right to appeal to Alaska Superior Court for
Correct.
the denial of administrative hearing, and the other is, I believe it's a general.
It is, but to that point there, sir, won't they just refuse to take the case because at the state or federal level, they don't recognize that as a defendable need, I guess, if you will? It's a local issue only?
No, through the chair, no. We have only one court system in the state now. We don't have a local court system, and our statewide court system is fully empowered to hear municipal law claims in the same way that they hear items that are completely idiosyncratic to municipal local code, like all of Title 21 and all of Title 23, none of which is in any way mirrored in state or federal law.
Well, currently, the way the ordinance is written, even in the absence of clear guidance of the Equal Rights Commission, because if the Equal Rights Commission follows the procedures and policies now, The appeal process is going to be, as I read it, 3 people of the same commission is the appeal. Is that, so where I'm concerned is if their impasse is reached inside the Equal Rights Commission, what do we tell the constituents or the folks that reach that impasse? Either procedurally through the Equal Rights Commission, this is what you're going to do, take it up to a Board of Adjustment or take it up to the Assembly. I mean, that's a bigger question per se, but I also beg to differ that we give clear guidance to the state on just what to do without precedent. In particular, we don't have precedent.
And ultimately, decisions of the Anchorage Equal Rights Commission will be reviewable by the Superior Court. The separate question of how these sexual orientation and gender identity claims should be substantively addressed is an emerging area of law. I've cited for you in this lengthy document that I understand no one has had time to really delve into. On page 11, there's a footnote 42, where the Federal Equal Rights Commission has itself started moving in this direction, interpreting federal provisions regarding sex discrimination to equally cover sexual orientation and gender identity claims. To the extent that there is any additional guidance necessary, I think it will come in this emerging case law forum, and really, frankly, would be difficult.
In
for the
individual
Assembly to-
protections, sir, in individual protections, or in the backing of say, an Equal Rights Commission capacity? Are individuals allowed to go to the federal level now and file, is what you just said?
That is my understanding, yes.
Gentlemen, I hate to interrupt
The
you.
last
too.
thing, and it's just for the
We've
record.
gotta get
is-
going.
is there are commission comments, charter commission comments. The bottom of the statement of my letter says the charter commission provided specifics to Article 2 on the listings of the rights guaranteed in the Bill of Rights. Can you provide an opinion of what their dialogue was when you get a chance? 'Cause I don't know if it's in there or not, and if you missed the question, but the charter commission in its founding in the 70s weighed in on what they said in terms of that, and there's language that speaks to expanding or contracting the duties there enlisted, and I don't quite honestly know what they meant. If you're saying that it's a floor, and the Equal Rights Commission was saying it's a definitive listing, I would like to know that interpretation from you.
And finally, through the chair.
Thank you, Mr.
reference
Falvey.
the Third Charter Commission's commentary on what was prohibitive and not prohibitive, that's in here. I didn't address the specific commentary to Article 2, which just simply said that the Bill of Rights is intended as a synopsis of the substantive rights granted in the remainder of the Charter. It is not intended to expand or modify the rights in question as they are stated in other parts.
That's the part I don't understand what that means. That when it says it's not intended to expand or not, does that mean it wasn't designed to give us blanket authority over discrimination against hunters or, other people that we didn't particularly
It
agree
is
with?
actually the opposite, which is that a claimant couldn't point to Article 2 of the Charter and say, I'm entitled to some protection that is not otherwise granted to me in any other part of the Charter.
With the specificity of the listing, sir, I'm not sure you can say
Okay, let's
that.
move on. We've
Thank
chewed
you.
up 18 minutes.
I didn't mean to.
I know,
think
Bill,
it's
it's
very
fine.
enjoyable for all.
Well,
Thank
I'd
you,
like
Bill.
to get it in writing, and it would have answered my
Let's get on to
questions.
amendment number 1, and Mr. Flynn is not here. It's from Mr. Flynn.
Mr. Chair?
Ma'am?
Mr. Flynn said that Ms. Tucker could,
Ms. Tucker, you want to explain 1 to us?
Yes, through the chair and on behalf of Mr. Flynn, I would just recall for the Assembly that there's been dialogue about where that threshold is by Mr. Flynn in terms of how to word the ministerial exemption. And what this amendment does is to make, as it shows here, change the draft, the language that's in the S1 version from primary duties to substantial duties. So the exception has a test that first the employment of individuals, they have to have substantial duties, and those substantial duties have to consist of and not just include the teaching or spreading of religious doctrine. And then it retains the change that was in the S1 version to refer to the religious community instead of a religious order.
Questions from Assembly members? Mr. Evans?
Bill, too.
Just
I know.
may clarify this a
figured
bit. The debate that surrounds this on the ministerial exemption is that there's concern that the word includes opens up too much room for organizations to say anyone's a minister. That's why Mr. Flynn is basically tried to narrow that and make it substantial, so that you'd have to prove that the person is substantially a minister and not just has small duties. I think there's problems with both of those. The problem with substantial, I think, we'll find is that given, as Mr. Starr was talking about, the ARC has no past record or experience with enforcing this ordinance. Substantial could mean an amount of duties, or also could mean the importance of duties. And I think it's problematic to have government, especially the ARC, trying to weigh in on what's important for each individual church as far as these duties go. I have submitted an amendment, it's number 8, that kind of tries to address this issue. The ministerial exemption has recently been addressed by the Supreme Court. It basically just stems from the First Amendment. It's just a way of interpreting the First Amendment to allow churches to have their ministers be outside of these discrimination laws. And so my proposed solution, and I've sent it to Mr. Flynn as well, is to just basically say that the standard that we'll use is the standard that was enunciated by the Supreme Court in deciding this, because it's a much more comprehensive standard. It does take into account that duties have to be substantial, but that's not the only thing it looks at. It looks at the title of the person, what they actually do, what other people do, and it's kind of messy because it's not a very black and white standard. But I think it's probably the best approach to identifying something that's going to vary from church to church and from religion to religion.
Thank
so
you.
that takes up my comment for mine too. So save
Mr.
time.
Starr.
Ms. Tucker, the way it's read in
Sorry.
Amendment 1, would teachers have to be
Didn't know this
ministers?
black with blue.
Teachers at a Christian school, for example, seem to be another area where I'm concerned about them, is that they would be held to a certain requirement to teach a certain manner. And if they taught subsequently that perhaps they didn't agree with homosexuality, or they put that doctrine into the school, they could be accused of discriminatory speech. Are teachers covered with this under the definition, or do they have to be a prescribed minister? Because my church, I've been to several, Catholic, goes by priest, pastor, minister. Do we run into differences then in definition?
I think that although the title here is ministerial exception, that the words teaching or spreading religious doctrine or belief, religious governance, supervision of the religious community wouldn't limit it to people who were not ministers. But as Mr. Evans pointed out, the problem as this has gone from the original to the S1 in this particular wording was an initial reaction that that I recall, I believe Mr. Flynn talking about was, he didn't want to have the exception swallow the whole by having every bus driver of a religious organization put in their job description that they're going to do a prayer in the morning and then have that go outside the exception. So I believe teachers are covered under Mr. Flynn's amendment. I don't think that's a problem. I think that, as Mr. Evans has pointed out, the reaching wording on this is difficult, and you see. Sort
Well,
of
I'll get
problem
to
with
number
that.
8. He sanitizes the wording and then really does emphasis the ministerial definition. So I don't want to talk about number 8 because we're on number 1, but thank you for your answer.
Mr. Evans, anything?
Just if it helps, the actual Supreme Court case that cited that was on a Tabor case was a teacher. That was a Lutheran teacher that taught secular subjects in their school, but also had a component that was religious. Spent in the court's record, spent about 40 minutes of the day doing religious kind of doctrine stuff, the rest of the time teaching math or whatever. And the Supreme Court came down with, in that case, based on that specific facts, that the teacher was covered by the ministerial exemption. But there could be other cases, how that's analyzed, where a teacher wouldn't be covered. It would depend on how the whole thing is set up.
Julia, question for you. Would this cover lay ministry? Because a lot of churches don't believe there's any need for ordain ministers. So would this cover ministers that are lay ministries? Because a lot of churches don't ordain people. They call people to be a minister for a period of time.
Like the LDS community.
Yes, I'm familiar with that.
Right, and
So-
I believe that that's why this is, that yes, this would allow the exemption to extend to lay ministers for the same reasons I was telling Mr. Starr about teachers, but the test is less on what title the person goes by within the religious community. And under here, the test is about whether and then, we have different words. This one changes it to substantial duties. So it would be a lay minister with substantial duties under this amendment consisted of teaching or spreading religious doctrine or any of these other things, and the lay minister, sort of by definition, as I understand it, would certainly fit in that category.
Okay.
And math can be spiritual, so we're good.
Okay, moving on to number 2. Here, Elva, you can be chairman, since it's mine.
Mr. Trainee?
What this does, this gives us finding for the reason we're doing this. The text of the amendment, I can read it for you. It's whereas discriminatory practices in the sale or rental of real property financing. I can read this to you. You can read it yourself. Basically what it does, it just sets a basis for the assembly finding that there is a pattern of discrimination. Because it's nowhere in the S1 version. I think we need to have this put in there. Some justification for having the S1 version would be a finding of pattern discrimination based on the testimony we took from people.
Thank you, Mr. Trainee. Mr. Bosky?
Thank you, Mr. Trainee. So, Mr. Trainee, it's my understanding, Assembly members were instructed not to ask questions during public testimony to make it go through faster. And I didn't see any evidence presented showing that there was actual discrimination. I heard stories from people, and during the testimony, I think it was showing that one day somebody said a story, the next day, Anchorage Christian Schools came back and refuted that story. So what we're doing now as a municipality is we're saying, even though we didn't collect evidence, we didn't hear from both sides, we're saying that the municipality of Anchorage discriminates against, or people within the municipality, there's substantial evidence, even though we didn't collect evidence, that there's discrimination in Anchorage.
I think you've been here any period of time, you realize a pattern of discrimination exists relative to this class of people. So it's my recommendation we adopt this as an amendment. And you can vote no against it, Amy. That's your
I'm
right.
just trying to get clarification.
Okay. I
I
think if you
never-
talk to people in this community, they'll tell you they've been discriminated against. They can point out when it's happened. So,
Thank you, Mr. Bosky. Mr. Trainee, Mr. Starr?
Through Chair, Mr. Palsy, is there cases where folks have felt that they've been harmed and in judgments of their lifestyle or in failure to sell a home or that? Has there been cases where they've actually taken it to state courts and asked for judgment? You earlier mentioned that they'll take anything, but yet, my question is, has somebody gone that you can document that they were provided judgment at the state level on claims of discrimination on these categories?
Through the chair, outside of Alaska, for certain, and I can provide some cases.
Or in Alaska, I'd like to know.
In Alaska, I'm not aware. At this point, that would be somewhat surprising because there is no codified protection for sexual orientation and gender identity within this type of framework. There are several cases, however, in the Alaska Supreme Court dealing with the ability of individuals to adopt who are lesbian, the individual gay organizations to advertise in the municipal blue book, and in all of those settings, the court did indicate that there should be no disparate treatment on the basis of solely the person's sexual orientation, and that the municipality could not discriminate against the organization for blue book purposes. So we could do some more research along that.
Just would like, even if they got thrown out because there was no coverage, if they were filed and there was documentation, public disclosure of this happened to me, and if the court's finally would say we're not covered under that capacity, at least you'd have a documentation that somebody said, hey, I was harmed. Thank you.
Thank you, Mr. Starr. Mr. Evans?
Yeah, just kind of echoing somewhat what Mr. Dombowski was saying, and since I've had this email conversation with this gentleman recently on this sort of issue, I think there is a concern if we try to establish a finding based on public comment, generally, not just in this situation, but any. Because we don't require people, it's not a hearing, we're not requiring people to prove their case at public comment. We're just asking them to give their opinions, whether they've been discriminated against, not discriminated against, whatever. So I think it'd be problematic to turn their opinions of what has taken place or not taken place into what would be a sort of a legal finding. I think it would be fine to have a preamble or whereas provision that says that, we find that discrimination is improper in these areas. But to say that, we find that it has occurred, I think would be a bit difficult given the nature of our public comment. And I think it would be just as effective if we just said that, we find that discrimination on these bases in these areas is improper, whether or not it's occurred.
Thank you, Mr. Evans. Ms. Tucker had a comment?
I do, and so my comment is a little bit different than Mr. Evans's. And so I think that, and I welcome input from the municipal attorney, especially if he disagrees with what I say, but I think that there's a completely different standard for making legislative findings based on legislative testimony than there is making a judicial or a quasi-judicial finding based on evidence, whether that's a quasi-judicial proceeding in front of the assembly or a judicial proceeding in court. And so it's been the practice in the 10 years that I've been here, and I've relied on that practice that existed before me, that there are instances where this assembly makes legislative findings based exactly on the testimony that they had. And it's not, as Mr. Bosky talked about, he said and then we refuted. She said, because anybody can use their minutes that they testify to tell the assembly about what they have experienced or what they think or whatever that may be, and the assembly can weigh in about that based on what they heard. And so, given the fact that the assembly heard several months of testimony in my tenure here several years ago, and heard several hours of testimony this time, some of it very compelling in many directions, but certainly you had individuals come up and testify, and none of that was refuted about that particular individual, and more than one having been denied housing because their credit report showed that they had a female name and they were now a transgender male, that they had employment situation. So in Mr. Trainey's defense of this, I think that it's, from a legal standpoint, totally appropriate up to the assembly to make it, but there's not a legal problem in making a finding. Mr. Paul?
Thank you.
Yes.
To the chair, I don't disagree with that at all. I think that the assembly has all the grounds that we need to come to a finding like this, which is within the comfort level of the assembly.
No. I'm just saying.
Oh,
No, I'm sorry. Thank you, Ms. Tucker. Mr. Starr, Mr. Trainey?
No.
Mr. Starr?
I'm just glad to
It's
see
more of
two
a-
attorneys that are
more of a
agreeing.
statement on how you achieved your argument, Ms. Tucker, that it's quite frankly a little bit offending to me, who I also sat through the previous hearings for that long summer of it. And so one of the criteria that we needed to do in that way that was packaged and phrased was in fact the proof thereof. And so the mandate that I remember walking away from, and this is where my friction goes up, is that
This is
if
going
I'm
to page
allowing
one, big
discrimination to
headline.
happen under
There
my
we're
watch,
at.
I take offense
I'm
to
getting ready to give you a
But the other
guide.
mandate was the requirement for the community itself, the broader-based
For the
community,
next one.
to illustrate and highlight using that. We clearly made those comments to that as, it's a no vote today, but tell us when and how it happened, and the Equal Rights Commission was on watch to do that. So my knowledge base is nobody's gone to the Equal Rights Commission saying, we know it's not a covered case, but this happened to me. So, before we say it exists and all the other things, that to me is frustrating because I allowed it to exist, and I still would like to see concrete. Refutability is a question, as we can't refute the statement about the housing rejection and or the doctor that refused to provide care. That's not within our purview to do it. So it does exist, perhaps. I would grant you to say that. Is that the motivation for doing this? The motivation for the Equal Rights Commission is to provide programmatic solutions, not necessarily to place blame. So let's be cautious we don't apply blame here, that we've done nothing.
Thank you, Mr. Starr. Let's move on. Mr. Trainey, you're the chair.
Number 3,
Under behalf of Mr. Flynn, this is offered by Mr. Flynn. He had initially, my recollection is, thought about including this in the S1 version to address, not to add anything new really to the ordinance, but to confirm the ordinance recognition of First Amendment rights. And so it's a caveat that says that nothing in this chapter shall be construed to violate the right of free speech and religious exercise guaranteed by the state of Alaska and the Constitution of the United States.
Mr. Evans and Mr. Starr.
Yeah, in part of my discussions with Patrick when we came up with the S1 version, this was originally included. It may even be included in next to my original version. I don't remember. But I said take it out simply because it seems it's just fluff. It's just, yeah, we can't infringe upon the First Amendment. Nothing we do is going to do that. But given all the public comment and the concern that people have about that issue, I think Patrick is putting it in there more or less for just to reiterate that issue, not because it changes anything substantively or legally.
Mr. Starr, sir.
And I'm ignorant a little bit here, is chapter .090 or is it chapter 5 that we're talking about amending with the, well, I think it covers language? Meaning my category is if it's only under religious exemptions, then why isn't that employer protected from his ability to provide free speech either in prayer or in comments relating to lifestyle choices? It would mean that Mr. Flynn only wants this protection under the religious section of the changes?
I believe that how Title 5, Chapter 20 in general works is that the religious exemptions that are under 090 are going to apply throughout the chapter, right? And so, because the beginning of that, if you look at, I think the clerk passed out.
Well, I'll give you the example, sorry for interrupting. 060 is educational institutions, and then you've got the other.
I think Mr. Falls has an answer for you, Mr.
I
Starr.
don't need a long one, just.
Yeah, through the
Mr.
chair,
Falsey?
the chapter is a reference to the 20s, so it would apply to everything that is prefaced by the 20 something.
Even though it says 090?
Right, because the way the code is structured, it is Title 5, Chapter 5, and the final number is the section.
Okay.
Mr. Evans?
Yeah.
Okay. Anything else on this one?
Just
Ms. Tucker?
Through the chair, by placing it here, that would save placing it under each of the 6 categories.
All right.
That are, okay.
Good, thank you.
Any other questions from assembly members? Thank you. Now on to amendment number 4. Here you go, LB.
Mr. Trainee.
The purpose of this one is to clarify that nonprofit affiliates are included within the exemption and to exclude religious organizations, including nonprofit affiliates, from extension of Title V to sexual orientation, gender identity, in the interest of maintaining the status quo of religious organizations. A lot of churches use, for example, Catholic Charities. I want to extend the protection to them. LDS, we use Desert Industries down in Utah, which Bill is familiar with. I think he worked for us for a while.
Oh, yeah.
Anyway, a lot of churches use affiliates. This would protect the affiliates from a charge of discrimination. That's the reason I'm bringing it forward.
Thank you, Mr. Trainee. Mr. Evans.
Yeah, thank you. Just in the purpose or summary of the amendment, it says to clarify that nonprofit affiliates are included within the exception. I mean, currently, as I understand it, because we have these exceptions, nonprofits aren't, which makes us different than some other states like Utah. But I mean, this would also include like Providence Hospital, which is a nonprofit, and it's not just we're limiting this to nonprofits that are affiliated with churches. It's any nonprofit. Is that correct?
I wanted it that are associated with the church, but I think Providence is with the Catholic Church.
Right. I mean, it's
So,
just so we're
Yeah.
all on the same page as to what you're telling me.
Thank you, Mr. Evans. Mr. Starr?
Well, to that degree, the baseball team is sponsored by the Christian school or the Boy Scout club, then is that how far we're reaching?
I hadn't thought about that. I'm sorry, Bill.
No, it's okay. Just between now and
Hadn't thought
Tuesday,
about
we'll
it.
converse.
We're going to converse.
Thank you.
Thank you, Mr. Starr. Any other questions on this one? Thank you, Mr. Trainee. Number 5.
Excuse me.
I'm sorry, Ms. Tucker.
Ms. Tucker?
I think that the
Sorry,
important
Elby.
part, the additional important part for the assembly to understand about this is that this amendment, in addition to adding nonprofit affiliate to this chain of bona fide religious or denominational institutions, is that this amendment takes out sexual orientation and gender identity from the extension of Title V rights for religious organizations. And as Mr. Trini mentioned in his purpose, it would maintain, it's intended to maintain the status quo that exists now for religious organizations, so that in this tension that the Assembly has heard between where the religious exemption on free exercise and association rubs up against the amendment to Title V that's proposed in 96 and 96S and 96S1, with an extension of Title V protections to sexual orientation and gender identity, it would resolve that by saying that, okay, it's going to stay the same, though. That, all these things are added to the categories that Mr. Starr was referring to before, financial, lending, all this we're going to recognize, but
I know.
in
I've been
dealing
busy.
with religious exemption, we're going to keep it just the way the code says now, which says that such organizations, that's that panoply of religious organizations, otherwise remain subject to the other provisions of this title with regard to the same old, which are race, color, sex, religion, national origin, marital status, age, physical and mental disability. And then that would sort of await, I think, what Mr. Evans was talking about, developments in federal and or state law that would then have to, by force of law, carry the municipality along
Give me
with
that
judicial
gavel back.
interpretations of what is going
Hit
to
you
be
with a gavel.
included within sexual or discrimination based on sex.
Thank you,
Ms.
Julia.
Tucker. Mr. Trainee. Number 5.
Okay, the purpose of this one is to refer the employment matters of appropriate due hardship standards, religious, and other reasonable need for accommodation standards in employment discrimination to the ERC review and recommendation to the Assembly by a date certain. I want them to take a look at it and then come back to us with what they're going to be dealing with. As far as we want them to tell us, give them some standards on what to look into, and that's what this will do.
Any questions? Okay, thank you. Let's move on. Mr. Trainee. Amendment number 5.
Number 5.
6, sorry.
6,
Thank you.
sorry. Yeah, there it is. Recognizes the fairness in the expression of beliefs at the workplace on equal terms with similar types of expression allowed by the employer. In other words, if your employer allows you to express religious beliefs at work, you can't be fired for doing that as long as the employer lets you do it.
Thank you,
To
Mr.
me, it's a
Trainee.
fairness issue.
Ms. Dombowski?
So, Mr. Treaty, in this particular ordinance, I can see benefits for both sides. For example, if an employer allows someone to express their beliefs on, topic A, we won't even name the topic, somebody with opposing views on topic A, they're both protected under this.
Yep. It's the
Thank you,
design of it.
Ms. Dombowski. Any other questions? Okay, let's move on to amendment number 7. Mr. Trainee?
Okay. Bona fide expressive association means a not-for-profit engaged in expressive activity where public or private judicially recognized federal law is protected by the First Amendment. What it does, we're changing on page 2, line 6, to include a limited exemption for expressive associations in keeping with U.S. Supreme Court inclusion of Boy Scouts. of America versus Dale.
Thank you, Mr. Trainee. Any questions? Okay, here you go, Mr. Chairman.
Did that go to the Supreme Court, Mr. Trainee?
I think it went to the Supreme Court.
Okay.
Mr. Evans, on 8?
Yeah, it's just basically what I said with respect to Mr. Flynn's original amendment. It's just trying to deal with what the correct standard should be as far as the ministerial exemption. I think the substantial that Mr. Flynn proposes in amendment number 1 causes some problems. I think adopting basically what's just the Supreme Court standard based on the First Amendment is broader, it's more comprehensive a look. I think it'll give the AERC a better opportunity to properly evaluate whether someone's a minister or not a minister under the First Amendment.
Are we asking this commission to determine if somebody's a minister or not?
Well, they would have to, I mean, if we have a ministerial exemption in the statute and somebody is charged with discrimination and claims that, no, this is a minister position, we're exempt from this, the AERC will have to, at that point, determine whether or not the exemption applies. So, yes,
I'm just wondering, you know how many churches are out there in the world?
more than 7.
Thanks to Luther, all kinds of them. But my question is, again, we're getting municipal government into churches. Okay.
Yes, sir.
Sorry.
I didn't
Star?
check.
Yeah, there you go.
Right next.
Mr. Starr and then Mr. Steele.
Well, then your purpose, Mr. Evans, and I'll ask you again on Tuesday, then, is to not provide the protections and coverages for the internal staff, the teachers, the bus drivers of the Christian schools or the churches?
As the way our current exemptions, there's a religious preference exemption which applies more broadly.
In the proposed ordinance, you mean?
Yeah, and currently in
Right.
existing law, we've had it for as long as we've had Title V, there's been this religious preference exemption which allows churches and other religious organizations to hire based on their denomination and their religion. It has some qualifying language
I've read it.
that one is dealing with your bus drivers and your non-ministerial type positions. The ministerial exemption is just that. It's more derived directly from the First Amendment, and it says that we don't want the government to be involved in choosing your ministers or your ability to fire your ministers. So it's a subset of the other one. But bus drivers, I think, come under the religious preference exemption, not the ministerial exemption.
Yeah, I just don't like our code referring to specific court cases. We don't often do that for the reasons of that your layman like me has to go back and review the court case, which is sometimes 80 pages long. So I would guide you that I'm not going to support it because of the reference to specific court cases. Certainly legislative intent and all the background thereof, but we need a law that's understandable and not so much predicated on the interpretation of a court that potentially didn't go all the way to Supreme or Superior and is still under conflict. So
And this one did go.
I didn't know that, Julie. I can't tell by, I'm not a lawyer, so no offense, but
No.
my point is made, is
Okay.
I'd rather not predicate it on previous court actions, especially in another state that's, not certainly that's working.
Anything else,
I want a
Mr.
law that
Starr?
works, that's all.
Mr. Steele?
Yeah, it concerns me that we had in our other base documents, it wasn't that you had to be a minister, it was that you ministered to. That means you didn't necessarily have a title, it was the duties that defined it as opposed to a title that you have. So that worries me a little bit.
Mr. Evans?
Yeah, I don't disagree with Mr. Starr's concern. I don't like the idea of actually adding a case as the basis because it does present all the
What happens if
Mr.
it
Starr referenced.
overturns it?
I think one of the biggest concerns, and in reality, I think by adding the ministerial exemption, which was my fault in the beginning, and looking back at it, and I think Mr. Falsey pointed out this to me at the time I did it, was that really the ministerial exemption is basically included within our religious preference exemption. And it's a bit redundant. So in a way, the whole debate over whether it should be included or substantial or this was on a Tabor case, it may be better not to have the damn thing at all and just rely on the religious preference exemption, which we've already had and takes into account all of it. But we can decide that.
Anything else on this one? Moving on, Mr. Hall. We're on number 9, sir,
Yes.
which is yours.
I've got real bad background noise where I'm at here. I would ask Mr. Evans to show courtesy. He and I have discussed this and I brought it forward, but I may be difficult to hear. So if Mr. Evans would walk through that, I would appreciate it.
Absolutely, Mr. Hall. Thank you. Mr. Evans?
Yeah, I guess Ernie and I were both contacted by, I think, by the same folks on this Amendment 9, I guess it is. And these were individuals who operate athletic facilities and other places that have public locker rooms that are open to families and people of various ages and everything. And their concern was, how they were going to handle the transgender issue. They seemed to be okay with restrooms and things like that, but they didn't know how to. And they were very actually supportive of trying to eliminate discrimination, but they just were sort of at a quandary as to how do we handle locker rooms where people are, by nature sort of naked in there, and they don't have any zones of privacy necessarily, and then they've been getting a lot of concerns from their customers regarding what's going to happen with respect to this. So I believe that this language came from one of their efforts to exempt out locker rooms from how we were treating restrooms and dressing rooms, and to allow locker rooms to be segregated based on anatomy more than on gender identity, as I think the intended consequence. And I think the language also allows the operators of the locker rooms to choose. I mean, they don't have to segregate by anatomy. I think Planet Fitness is what I've heard is one that already is their policy is they allow it by gender identity. They've been doing that for a while. So locker rooms under this would have the option of how they want to do it. It wouldn't be required one way or the other. I've since when I got the calls from those operators, I've also reached out to people in the LGBT community to see how this actually works, and because I'm kind of at a loss for explaining how it's going on now. And I think there is some concern that law, if it's segregated based on anatomy, which makes the vast majority of us comfortable, it does cause problems with their folks who are actually at
Crossroads?
and they're way more vulnerable and don't want to draw attention to themselves, where they're living the life of one gender and are forced into the rest of locker rooms with other difficult issue of all the issues that I've encountered in this whole mess. This one seems the most difficult to find a solution, but I believe that's what Mr. Hall is trying to do with this.
Okay. Mr. Starr?
I didn't have a question on that one. I have a comparison one on Amendment 15.
Okay.
Tries to address it as well.
That's the one.
Okay, when we get down to that one. Any other comments on this one? Anything, Mr. Hall?
No, but I greatly appreciate Mr. Evans doing that presentation.
Thank you. We're down to number 10, and that's yours, ma'am.
Thank you, Mr. Chair. It seems some of our amendments are definitely overlapping, so, but it was an attempt to address some of the public accommodation issues and not extending sexual orientation and gender identity to those religious organizations. For example, if a church maybe has functions in their gymnasium, obviously there could be issue if they are being forced to hold an event in their building that is contrary to their religious beliefs. So this is an attempt to just again deal with that issue. Any
Questions from assembly members? Thank you, ma'am. 11. That's yours too, Amy.
Oh, this to me, I've been reading a lot around what's happening around the country, and one of the things that I wanted to ensure is that there's not retaliatory type actions on the behalf of the municipality because of an institution might apply for a lease or a loan or contractual business with the municipality. The example I give is in Colorado, where the city council there is refusing to renew a lease for Chick-fil-A. And I think this will create protections, not only for people on one side, but people on both sides. So for us as a municipality, I think it's fair for us to measure whether it's Ben & Jerry's or Chick-fil-A, I don't care. Do they meet the requirements? Are they, within all the zoning laws? Are they, a competitive bidder? Those are the things we should look at. And I think as a municipality, this is just an affirmative declaration that regardless of what side of an issue somebody comes down on politically, we're not going to discriminate or retaliate against you.
Question from assembly members. Okay, ma'am. Yes, ma'am.
I want to just point something out here. Under 96S1 now, there is an addition of subsection B, which says where the provisions of this section conflict with provisions of Title VII of this code, this section 520.070 shall govern. And the only rub that I see about what
Mr. Dombrowski?
Member Dombrowski is, has here is that and I'm going to use an example of the animal control facility. The municipal animal control facility is contracted out, and everybody got to bid on that. And a subsidiary of Doyon, a native corporation, got that bid. And Doyon, as a native corporation, is allowed under federal law to preference shareholder members. And the municipalities' provisions in Title VII and elsewhere say that any bidder needs to be open in employment and can't have preferences. So when Doyon bids on that, they have to let go of their preference. So the only concern that I have with how this is going to match up with what's in existing here is to make sure that there is some clarity that in having the provisions exempt here doesn't mean that a facility can apply for a contract and have it be awarded with exemptions that are beyond what is in Title VII. So an example is the other Boy Scout case where the boat ramp back east was donated, the fee was waived to the Boy Scouts. Municipal fees were waived to the Boy Scouts because of their, good works. And the case was brought and taken to the court by atheists who said, the Boy Scouts don't let people who don't believe in God into their organization, so you shouldn't be waiving or giving special benefits or letting them compete on an equal basis because their core values run amok of every taxpayer's largesse. So I just want to make sure that the Assembly is aware of that rub here.
I have a follow-up.
Mr. Dombrowski and then Mr. Starr.
I'm a little bit perplexed, Julie, because you helped me with this one.
Yes, I did.
I don't remember that conversation. So are you, I guess, I was trying to follow. I didn't really
Mr.
follow.
Attorney.
Okay.
Can you just succinctly tell me? I think, to me, I've been calling this my non-retaliation amendment, and I think that it's fair for both sides to not be retaliated against because of, views that they express that aren't in the context of the lease or, the land they're trying to get rezoned or whatever. I think that's
because in the context of what Assemblymember Dombrowski is talking about with the Chick-fil-A is that Chick-fil-A has, as I understand it, has a concession at the airport or at someplace, and for reasons based on support that I don't see in our situation, the city council in Denver is considering upping their lease because Chick-fil-A makes significant monetary contributions to organizations that oppose extension of gay rights and rights for transgenders. And so they're going way beyond that. My only concern here isn't about the retaliation, is that we're clear on the deny or prevent an entity from participation, coupled with this provisions that this code is going to bump Title VII, doesn't create a situation where not only are entities allowed to participate equally, but they don't have to offer the services that are intended and the employment practices that are intended, as in the example of.
Well, I think we'll work offline for maybe some clarifying language, because the intent of this is non-retaliation.
Thank you, ma'am. Mr. Starr, sir, and then Mr. Steele.
I want to ground the body in the explanation a little bit on why Mr. Evans took this approach, and that's to expand the duties and responsibilities of the Equal Rights Commission. Chapter 5 starts out with 010, and that talks about the policy of the municipality that's being modified to include these things. 020 is the formation of the Equal Rights Commission and the duties and responsibilities thereof. So now what we've done is we've said through several amendments, including the one that Mr. Evans has put out there, is that we're going to bypass the bidding review board. We're now wading into Chapter 7 purchasing code language through that. So Mr. Jambowski's need to put it in there, I think, is very much appropriately, because if the vendor, contractor, or otherwise is turned down for a specific contract, they're going to go to the Equal Rights Commission to prove that they didn't discriminate, or that the case, and or the municipality now is going to have to defend itself through the Equal Rights Commission for bidding review board concerns. And I think we're going into some dangerous water. And Mr. Evans, you need to educate yourself on what the bidding review board does under Chapter 7 when you have a petition to deny a contract for bid. And if it's
Mr.
if
Starr,
it's
can
not
we speak
clear,
to the amendment, not the individuals, please, sir?
I think it's misplaced. We have to expand it then to provide protections under Chapter 7, which is the purchasing code.
Mr. Steele.
Yeah, I think if we're going to provide fairness, we need to provide fairness. And to give an extra benefit to one bidder over another is not right. To hold Chick-fil-A, let's say, accountable for what they do with their earnings is probably not appropriate to the contract that they're bidding on. The bidding is separate from what they're doing with their earning. So the examples don't necessarily work, but I think if we're going to have bids, all bidders need to be able to play on a level playing field.
Well,
Thank you, sir.
Chairman,
That's the goal. That was the goal.
It started
Last
out with
comment,
women
Mr.
in
Starr.
minority bidding, though. You've got women in minority bidding opportunities. You've got what Ms. Tucker illustrated with the Native community. So this is where, again, inside Purchasing Code Chapter 7, we've just got to be careful that we're not trying to funnel it all through the Equal Rights Commission, because Purchasing Code has those exceptions and guidances. So that's my
Thank
only
you.
observation. Is that-
Thank you,
Mike's
Mr.
not
Starr.
fair, is what you're saying.
Thank you, yes, exactly.
Item 12, Mr. Jambowski, you were busy.
This may be shocking to some, but Mr. Evans' religious conscience exemption language is thrown on me. And, I think with a lot of discussions around the country, when we see people of faith exercising their faith by not wanting to participate in what they deem a religious ceremony, and then being essentially financially ruined, or I think is one that is directly in conflict, quite frankly, with the intent of the First Amendment. And so whether somebody's a minister or not a minister, I'm not saying that if you're baking a cookie, you can't sell that cookie because you don't like, that person's sexual orientation. But what this does say is, specifically when we're talking about weddings, or we're saying that you can't force somebody to participate in your wedding just because it happens to be their line of work. And again, I don't have to expound upon it. It's written down there clearly. We've had this discussion lots. And this is just an attempt to protect religious freedom.
Questions from assembly members?
I have one, just briefly.
Mr.
I'm not
Starr.
trying to beat it up, but this is a big topic for me, which I've vested all summer and a long time ago. I'm doing it again. But Mr. Evans, in your version, and maybe Mr. Flynn's version, but he's not here, Section 10, you're talking about the exemption that allows that, but you also qualify it to persons of the same religion or denomination. You know what I'm talking about in your language. It's on page 9 of 12. And what I'm getting at is, if in fact you want to prevent some of the examples of, I bake cookies, but I don't support lesbian same-sex marriage, or however that goes, that to me doesn't speak to your intent here to persons of the same religion or denomination. So if you took out two persons of the same religious and denomination and read it that way, it says that you could provide those services based on my business owner's preference. That's the way I interpret it. Wouldn't that be a better amendment?
Well, you probably should ask Mr. Bowski that, but are you talking about on page 9 under 520-0908?
It's line 43.
Yeah, that's just existing language. That's what the current law is in Anchorage.
Yeah, but you've expanded the religious preference by deleting language and removed it. So I guess I just asked you, as somebody who studied the topic pretty well, is could we accomplish the same broader reaching exposure, not limit it to the same denomination? Meaning I could sell cookies within my church, but if I did want to sell cookies to the other guy down the street, I didn't have to. It's a bad example, of course, cookie sales, but
Yeah, I mean,
how did we win here?
And I may not be entirely tracking what you're saying. I mean, the language in A there, the religious preference exemption, just applies really to religious institutions. What Ms. Dombowski is proposing on the religious conscience applies to individuals outside, may not even belong to any church.
I get you. You authored this, so my point is you've heard testimonies that have spoken to those folks that have been put out of business or sued or lost their homes, or all those stories, particularly the ones that refused to cater the wedding in whatever state that was. I don't know it offhand, but do you have any reason to not support expanding it? I mean, why wouldn't you, with the testimonies thereof that the law ran afoul? And if we do, how do we do it?
Are you asking me if I'm supporting Ms. Dombowski?
Yeah.
Smith? I'll tell you Tuesday.
You're not going to get the answer to that question, sir.
I want to do work between now and Tuesday to study the topic.
I know.
You have, so fair enough.
Anything on
That's
it-
your
anything
answer.
else on
I
Amendment
called you
12?
Twice, you don't answer your calls, so.
No.
Okay.
I would just say, like, again, my view of this, when we're talking about religious exemptions, some are putting in as far as religious exemptions only apply to churches. I don't believe that to be true. I believe people, religion is something that's practiced every day, no matter if you're in church or not. And this is just trying to respect that. And, it's not a broad brush. It's just specifically saying with respect to ceremonies, rituals, or observance that is in conflict with a sincerely held belief. I mean, that's what I'm trying to do.
13?
Oh, we're back to the restroom. So, I had multiple ways.
Back to the restrooms.
Back to the restrooms. I had multiple ways that I was going to address this, and this may not be the last iteration you see from me, but I felt this was a fair way to do it because it leaves the control within the operator's realm. Meaning, if somebody owns a health club and they want to maintain gender segregated restrooms based on anatomy, they could do that. But if somebody had a health club and they don't want to, they don't have to do that. So this gives it back to the local businesses, the local entities. I call this my modesty exemption, quite frankly, because there's a lot of discussion about the people who come into a health club that are transgender, that maybe they identify as a female, however they still have male genitalia. And quite frankly, from my perspective, I don't want to be in a locker room and have someone with male genitalia seeing me naked. That's, in conflict with my faith, and it makes me very uncomfortable. So I can choose as an operator to develop policies to allow people that have those modesty beliefs, as I do, to, go to my facility, or if it doesn't bother me, maybe I want to go to the other place that, allows both. But I think this is an attempt to try to strike the balance of both sides, and it really creates local control, basically back to the business owner.
Questions from assembly members? Okay, Amy.
Is modesty?
Mr. Steele?
Is modesty a faith-based?
Yes.
I think you'll find modesty among people that have no faith at all.
Yeah, absolutely.
It's different.
So, I mean, quite frankly, Mr. Steele is inappropriate for a man that's not my husband to.
Well, and that may be the issue, and so maybe separately but equal in that particular case. would be
Well, and I think
appropriate.
one of the things you'll see when you go down further into the provision, nothing in this chapter shall be deemed to require the provision of equal or special facilities to accommodate any person. So, meaning if somebody chooses to go into this and say, okay, I'm going to have a modesty policy or a policy, to say it's going to be, it's similar to Mr. Hall's amendment, it's based on anatomy. If they choose to do that, it's not going to require them to build another locker room as big with a jacuzzi if the one has it, or a sauna. But it is, it gives them the ability to create something maybe, functional and nice, but maybe not, so it should try to strike a balance really for business owners. And, business owners ultimately will have the ability to set their own policies.
Bottom line is they need to cater to the desires of their clientele.
And that's what I'm trying to do.
Anything else from assembly members?
No.
Moving on. Amendment number 14, Ms. Nabowski.
This one is very, very clear. I am moving an amendment to make this ordinance effective upon condition of the affirmative vote of the people of Anchorage.
So you want to send this then to what, the voters?
So essentially, the effective date would not take place until after, right here. This ordinance shall become effective upon certification of the next regular election of the municipality if, and only if, a proposition for an advisory vote on approval of the ordinance is passed by a majority of the municipality of Anchorage voters voting in the advisory vote on April 5th, 2016.
That means we'd have to put it on the ballot.
That's exactly what it means. Mr. Chair,
I just want to specify, Bill, I'm
have-
not arguing with
and
you.
I want to be very, very clear. I think Mr. Starr makes has asked some very robust questions regarding whether this should be a charter change or not. I tend to agree with him. But I also see the amendments that are coming forward, and I have just now heard this morning the opinion of the Department of Law. Taking that into account, I have drafted this amendment to say, this is an issue that I believe the voters of Anchorage have voted on, and I believe they deserve to vote on again. I think it's something that we represent the people, and I'm not afraid to do that. So I'm not afraid to let them vote on it.
Question from assembly members.
I have one.
Mr. Starr.
Not specific to Ms. Dembowski, but Ms. Tucker probably knows the answer at this point. No offense, Mr. Falsey, but the ability such as 8037 to move overturning the actions by referendum. Now, if the assembly puts it on the ballot, is there any difference between that 2-year criteria that measures the topic can't come back after 2 years? Is it the same?
No, this is an advisory vote.
All right, all right.
She's very specific, so it's
All
not
right.
a charter amendment.
Thank you for the clarity.
And it's not an initiative.
So, one thing to
Go
follow
ahead,
on
Ms. Dembowski.
Mr. Traney, I look at this, and depending on how balanced it was, during the debate, I heard some really moving testimony from an individual who said you should think about the other side. And that's what I'm trying to do. I'm trying to think about both sides here. And what I recognize is, as a legislative body, if we do not strike a balance, and if we choose to push forward and steamroll and only look at our side, I think what will happen is we'll have a referendum, which means the law would be suspended anyways, and there will be a vote. This is an attempt to get the most inclusive ordinance passed. And then we have the control of drafting what the ordinance looks like and then putting it in front of the voters and saying, do you want it, yes or no? And I personally am very comfortable letting the people of Anchorage decide that question. I have faith in them, and that's why I'm putting it forward. I'm trying to potentially stave off maybe a referendum. So that's why this is there.
Thank you. I
Other
have the
questions
floor,
from
but,
assembly members?
Ms.
Mr.
Jones,
Starr?
could you send to me or the rest of the assembly the 2012 verbiage on the ballot? I think it was 2012, we went to the polls on that. Can you tell me how it showed up on the ballot, as well as the actual question in front of the voters? And then thirdly, the results, not by precinct, just generally. Thank you.
Anything else, Bill?
Nope.
Okay.
Back in the bathroom.
Amendment number 15, Mr. Starr.
I propose changing entirely the first section of this exemption, and the way that reads is that these things are excluded from the ability to say you discriminated against. And so in this case, I suggest that the text reads segregating the use of restrooms, locker rooms, and dressing rooms by gender, so that individuals using restrooms, locker rooms, and dressing areas will have a reasonable expectation that they will be sharing the room with individuals who have the same assigned sex at birth, or those who have completed sexual reassignment surgery. Operators, owners, and management are hereby allowed the flexibility of procedures and facility rules to ensure appropriate accommodation of all users. Nothing in this chapter shall be used to require the provision or construction of unique facilities to accommodate any persons based upon sexual orientation or stated gender identity. And what we focused apparently on is the locker rooms related to the very, very public facilities of the workout centers and the clubs. But as an employer, I had a changing room for my drivers that came to work and put on their delivery uniforms. Nurses do it all the time as well, where they come to work and change into their scrubs, or surgical centers have places for that. So what I'm trying to do is allow that flexibility to extend to the employer through this public accommodation, and changing some of the words that have driven friction. Special. I'm not looking for special either. I use the word unique. I also refer to it most as gender identity, and then provide the flexibility that someone could prove to their employer that, hey, look, I'm fully switched, and offensive perhaps to those that I'm ignorant to how the process works. But if you've had corrective surgery or changing surgery, then you're okay. But I want to keep that pretty clear. There's been 3 attempts at it. Maybe by Tuesday we'll have a common goal from all of that. But I think the employer, as well as the owners of these facilities, and then thirdly, the operators under contract. Oil companies have third-party doyons, and those folks come in and run facilities for them. It may not be the employer's intent to discriminate, but what if their subcontractor comes in and runs a facility and says, this is how it's going to be? I want to capture them too.
Question for assembly members. Bill, for specificity, and I know you're into that, what type of proof do you have to give to prove on the reassignment? I mean, you going to take pictures? Do you want a doctor's statement? What are you looking for?
Well, I started to go down that path, and then I went to the, I don't know the answer to that, to be honest with you.
Because it's going to be awfully private.
Yeah.
I couldn't even begin to fathom how you would ask somebody to prove.
Yeah, well, the next amendment talks about that.
Huh?
My
Okay.
next amendment talks about that. If you can.
Anything else on this one? Julia?
I think that the original version, the S and the S1, have made an attempt to answer your question in the definition of gender identity. And that includes at least the S1 includes the addition of a person's gender identity may be established by evidence of medical history, care or treatment of the gender identity, consistent and uniform assertion of the gender identity, or other evidence that the gender identity is sincerely held, or the person's gender-related self-identity, and not being asserted for a common purpose. So I think within that, there are options that the...
You think there's enough in that to cover this?
I'm not trying to wordsmith it, but I specifically left out the gender identity statement on my first line of that, is that they're allowed to segregate by gender. Yours in the earlier one, to me, conflicted with the gender identity statement as well, is that I want to be very specific on that. And we could always bring up Ms. Dombowski's earlier version of anatomy and name it, but I thought that the gender specific, with the flexibility that if you fully transitioned, you're accommodated. How you prove that is hopefully covered in my next amendment, which asks them.
There's nothing else on 15. We'll move to 16.
This one is been brought to me by those folks that have to provide or potentially need to prevent discrimination or provide accommodating facilities is sometime or another under this category, specific to the exemptions of it, you're going to have to ask them. I think you're going to have to ask them in some form or another. And so my amendment is to add a new section under here is that by the answer, soliciting and obtaining gender-specific information by questionnaire or other means for the purpose of facilitating the gender-specific accommodation in compliance with law. You know, it's one thing to say, I don't care how old you are, can you do the job? It's another one to say, I don't really care what color you are. But it's another thing to say, you know, bluntly, I can't tell if you're a man or a woman, how am I supposed to accommodate that request? And so I think that by bluntly asking them or filling out this form would allow the procedures and the flexibility in the decision-making to return to the employer place or the place of business and let them decide. Inherently, I get the sense that people aren't interested in overtly discriminating. The public may say otherwise, but I think that the guard here is, do we discriminate unknowingly because we didn't ask the question? So I think you're going to have a questionnaire or a private conversation or some mechanism to exchange information. This is the way I propose it.
Questions from 16? Mr. Dombrowski, we're coming back to you, man.
Thank you, Mr. Chairman.
We're not in the locker room anymore?
No, we left the locker room.
Okay.
If we can get through this without actually having to use specific genitalia references, I will be thrilled. This has to do with the definition of employer. Again, this is an attempt to exclude churches and other bona fide religious organizations from Title V by redefining employer in the interest of preserving the free exercise of religion. So the text of the amendment would be employer means an employer, public or private, of one or more persons with respect to sexual orientation and gender discrimination. Employer does not include a bona fide religious or denominational institution, organization, corporation, association, nonprofit, affiliate, educational institute, or society. That's pretty straightforward. I'm just trying to, again, just reiterate what we've seen in other amendments that religious protections are valued by the municipality of Anchorage.
Questions from assembly members? Mr. Evans, sir.
Just so I understand, though, this would, no, I understand, no question, no repair.
Ms. Tucker.
In the purpose summary of the amendment, I didn't know the typo, to which I apologize to Mr. Bass before we try to put this together. But it's not to exclude churches and other bona fide religious organizations from all Title V. It's to exclude them from the extension of Title V under the 809.
I think that's what I meant. When I read it, I read it for the sexual orientation and gender, because I noticed it as I read it.
Like, thank you. But for everybody else who has.
Yeah.
Thank you.
That's why I expounded and
That's all the amendments. So, anything else? We'll see each other Tuesday. And this is under old business, so we can pick it up about any time we want.
You're not going to entertain amendment changes? Or
I'm a no vote on any amendment that comes through we haven't seen now. You guys can vote when that comes
well,
up.
what if it's a great idea, Mr. Chairman?
Then you have to convince me.
Okay, I take that challenge.
Okay. What?
I'll take that challenge.
That's fine.
I may not have
Amy, but for my vote, unless it's an outstanding home run, I'm a no vote. You can vote however you want.
Is it
I just
6
don't
to
want
overrule
things thrown at the
chair or
last
is it 8 to
minute.
overrule chair?
6.
What?
Is it 6 to overrule?
12.
What if there's a typo?
Mr. Chair, you have a confirmation hearing at 2 o'clock with
Yeah.
Chris Toller.
2 o'clock.
That was a no.
So, huh? Let's see. It's 1:24. There's food back there, so thanks for being here. This work session's over with.